appoint anybody who's trustworthy. And the reason Jackie says someone in state is because if you appoint someone who's not in state, it's more difficult for them to carry out the tasks of being an attorney, an executor, and someone's going to have to be appointed to be an agent for service in case somebody makes a claim against the estate to be served.
The other issue I've encountered too is I have someone's estate that I'm probating, and they name two people as executors, one who lives in California, one who lives in Rhode Island. So anytime anything has to be signed, we have to send it to California, and then that has to come back to Rhode Island, and it has to be administered through probate. Right. Even as little as signing a check, right, it has to go to California. One executor has to sign it, come back to Rhode Island, the other signs it, and then you can deposit it in the bank. And so it becomes complicated.
I had one, and there's some things you can do by the internet, you know, email. There are some things you can't do by email, and signing a check obviously is one of them. So my executor was in Spain, and it was difficult just to get things emailed back and forth. So he eventually declined to be the executor.
That's what I was going to say. I get a letter of declination that makes things a lot easier, but some people will not do that because it gives them control over the estate, and especially if you have siblings that are not getting along too well. Right. It's very difficult to...
That's where we have the most fun in probate court.
I would imagine. Yeah. Address, if you will, we're talking family matters. What about children when there are children to be cared for and someone's deciding what should be in trust and how it should be taken care of?
And who should care for the children?
What I like to do in wills is I advise the clients, think about who you would want to take care of your children if both you and the father are no longer here. So we name a guardian. So I put what's called a guardianship clause in the trust, in the will. But the guardianship clause can also empower the guardian with certain rights. For instance, the guardian would be able to handle all of the financial affairs for the child. My guardianship clause would also indicate at what point money can be invested, at what point money can be distributed to the minor. So I always think that's a good idea, especially since the Station nightclub that created a problem, because a lot of people, the people that died, some of them were single parents, and then they had issues as to who was going to be the guardian of the child. So they had to go to probate, family court. Family court.
And so oftentimes you might have somebody who's good with money and somebody who might be better suited to take care of the children. That's not a bad idea either, to create a guardian and then a trustee who will control the money, the guardian take care of the child.
And is it likely that you'd have one person who could take care of both?
If there's somebody who's suited to do both, you could do that.
And that would likely be a family member?
Yeah, it could. But just because it's written in stone doesn't mean it has to be, because anybody can petition the court as a guardian.
Right, and think about this too. Divorced couples, oftentimes I'll have somebody come to me who has a child, and they want to name either their new spouse or somebody else to be the guardian of the child, when there's another spouse, a mom or a dad out there, who by law is probably presumed to be the natural guardian and next parent of the child. So then what happens is you just set up for a probate contest oftentimes. And I've had cases where the dad, who's been out of the picture for many years, comes in and he now wants to get involved. And really it's because he doesn't want to pay child support anymore, and really has nothing to do with the child and hasn't seen the child for many years. And so we've had some very interesting cases surrounding that issue.
In that case, a court would have to determine what is in the best interest of the child. It wouldn't be probate court. That would ultimately go to family court.
You mentioned a few moments ago that sometimes people will decline being an executor of a will, perhaps even if they were out of state. What about someone who is likely to take care of a will? When should someone be what are the responsibilities for someone who needs to take care of a will? What are their responsibilities?
You're talking about the executor?
The executor of a will.
State law says you have to file a will within 30 days of your death. The law, there's some sanctions, but they don't usually...
Yeah, a lot of times because there's nothing to probate, people don't do it, but you theoretically could file the will without probating the will. Yeah. But the bottom line is, if there's something that needs to be probated, once you have gotten through the real issues of the funeral and doing that, the next step is to go ahead and find out, is there a will, who has the will. A lot of times, one of the things we do when we do a will for somebody is we'll often tell them we have a place off-site from our office where we can keep the will fireproof, safe, and all of that. We stamp a copy for them that's signed, a photocopy of it, which there's a statute in Rhode Island, if the original is lost, you can probate the copy. which is, change with technology. And, talking about technology, we talked before we started about codicils, and many times people would come to me and say, I want a codicil. Well, when wills were written on those type little onion pages,
Typewriters that we used to use?
It was hard to change a will because you'd retype the whole thing, and so you'd do a codicil, which was an amendment to one little paragraph or something. As opposed to now, they're on disk. It's easier to me, let's redo the will and re-sign it and do it right.
A simple matter of copy and paste versus having to redo the whole thing. When someone is an executor, are they paid?
Yeah, the statutes provide that they can get a fee, albeit it's not anything quite excessive, I think, anyway, 3 to 5%.
Well, actually, what they're doing now is hourly.
Okay.
And keep track of your time. If there's a lot of time put in, if you're compensated at a fair rate, it's not exorbitant, but
there's a lot of work.
It has to be approved by the court as well.
And the court has to approve that.
Attorney's fees have to be approved by the court.
The attorney's fees for?
Representing the to get the estate probated.
Yeah.
And when someone is thinking about those taxes that have to be handled in probate court, that's a big issue. Address
a lot of people come to us and say, I don't want my estate going to probate because I don't want to have to pay the taxes or the fee or whatever.
A common comment.
Honestly, depending on the size of the estate, it's not that exorbitant. The filing fee is 1% of the personal estate, which means the money, not the real estate. And it's up to a maximum, and it's not that big a number. I think it might be $2,500 or something in that range. There's a delay in probate court of passing assets because creditors get to make claims within 6 months of the date that the will is admitted to probate. That delay is more of a hassle than the amount of the money that you have to pay to probate a will.
People are scared by the name probate, by the term probate, because they think court, why do I have to go to court? It's going to make life complicated, it's going to cost a lot of money in legal fees. But honestly, it's just merely a process just to administer someone's estate. It's not that.
And while people talk about the do-it-yourself everything online these days, and I guess you certainly could do an online will, I'm sure you're going to be saying you might want to think twice about that. What happens if someone wanted to contest a will? Is that something that could actually be done online too? Is there a do-it-yourself?
No, you have to file a claim with probate court.
And that means we have to have a lawyer, correct?
Not necessarily, no.
And what happens, how does one go through that process?
When a will is going to be admitted to probate court, the heirs at law, the people who would have inherited, whether they're in the will or not, are notified, and it's advertised. So if somebody wanted to come to contest the admission of a will to probate, they can come that it's scheduled to be heard and tell the judge that I think that this person wasn't in their right mind and the will should be not admitted. And then they'll set it up for a contest and a hearing.
I guess another question that comes up when people talk about their spouse passing, with or without wills, with or without estates. If a spouse dies, are you, as the survivor, responsible for their debts? And to what extent are you responsible for their debts? Ethically, legally?
Legally.
Morally, yeah. Morally. If you are a joint account, if an account holder of the particular debt, like a credit card, well, yeah, then you are responsible. But ultimately, the estate has to be administered to pay the debts of the estate. So if there's money that, there's a priority of what gets paid first, funeral taxes. So if there's any money left over, well then, and there are claims that are filed by your creditors, then they have to be taken care of unless the estate is declared insolvent.
So the answer, as Jackie's saying, is
maybe.
If you're not a co-signer on a debt as a spouse, you don't owe the debt, but the estate may owe the debt. And as Jackie says, there is a priority, and funeral directors must have a very strong lobby because they're number
first.
one.
Yeah.
That's an interesting thing to note, isn't it? When something is going on in that whole probate process that you say could sometimes be fairly quick, fairly efficient, sometimes not, how does someone stay in tune with what they have to do if they have more work that needs to be done? Just as we hear when someone is an executor of an estate, they might also have a lot of work, ongoing work. How do you stay up to date with all of those other people who might have a claim on that will? How does that happen?
Well, you do hear nightmares about estates that have been open for 5, 10, 12 years, you know. And there's sometimes valid reasons for that. The goal of the probate is to take the assets